Before we begin, a usual announcement by the Chief Justice. In the 75th year of its existence, the Supreme Court of India launches a small initiative which has the potential to have a big bang impact. WhatsApp Messengers is a ubiquitous service in our daily lives and has taken a role of a powerful communication tool to strengthen the right of access to justice and enhance transparency in the judicial system. The Supreme Court announces integration of WhatsApp messaging services with its IT services. Now, advocates on record, parties in person will receive automated messages regarding 1, electronic filing, 2, cause lists, and 3, orders and judgments. The automated messages through WhatsApp will be received on successful filing of cases, notification about objections being marked by the registry in the cases filed, and registration of cases. All members of the bar and the registry officials will receive cause lists as and when published by the registry. In addition to accessing orders, judgments through the website, now all stakeholders, including members of the bar, will receive them on their mobile devices. The Supreme Court of India's official WABA number is 8767687676. There's a caveat. This number transmits one-way communication. In short, it is neither a callback nor reply back number. This facility and service will bring in a slight change, or significant change in our daily work habits, but will go a long way in saving paper and our planet Earth. So
it's one more revolutionary step.
Everybody will even
one more revolution.
We get the cause list on our cell phone. We don't have printed cause lists which I have sent to the judges in their offices anymore.
Oblate to your Lordship.
Please, ma'am. Lord, just picking up from where we left off yesterday, Lord, I have prepared a short note because I did notice, my Lord, that much of what I said orally forced your Lordship to put it down in hand. So, my Lord, I have taken the opportunity, a very short note, my Lord, putting everything down, so it's by hand for your Lordships, and your Lordships don't have to.
Over the hard copy, or you?
I have circulated the soft copy with your Lordships
soft
also.
Copy here, do
I'm not.
This one is volume. Note on the context of leading to the conclusion.
Yes, Lord. So, Lord, it's Roman 7 onwards.
All right.
Roman 7 onwards. And it's actually part of what I argued yesterday. I just want to show your Lordship that I've recorded it in a note so that it's clear to you, Lord.
It's, Your pagination is in continuation with the earlier note.
It's in continuation. So, Lord, we've checked all of that, Lord, and I don't think your Lordship will have any difficulty with that. And Lord, just as by way of, Lord, testing that out, if your Lordship just sees note 7, Lord, this is how I had tried to formulate the question for your Lordships, and I've added 1 or 2 more thoughts to that. So, Lord, that's at page 93.
Hello, Moto. Hello, Moto.
There are stories, and then there are stories of battles fought, of friends made, of bridges built, in strokes of paint and sweet songs sung. The most beautiful stories, however, are the ones about you. Nebula by Titan. Your story, your legacy, crafted in 18-karat gold.
Yes, now let's read the note.
Page 93, Lord, it's note Roman 7. Lord, I've actually formulated the question. Lord, if your Lordships, Lord, find this acceptable. Lord, the issue in the present case, if all of your Lordships.
Just let us
please,
get our house
please,
in order.
Please.
Not in order.
Please do. Please do. The only thing with the electronic record is that it's a little more difficult to navigate than paper. Lord, I have been a great proponent of the same, my Lord. But the only thing is a little difficult to navigate, it's a little difficult to look at 2 things at once. Oh, that's what I find. Those are the two difficulties. Sorry, my lord.
Fingers at 5-6 places.
And my lord, yes, my lord, at great peril to the trees, my lord, it still remains a more convenient form, my lord. Yes. But a balance is a good idea, I find. What is bulky is here, what is not is here.
You can do everything now in the electronic form, so.
Your lordship's, my lord, your lordship's example,
easier.
my lord, I hope is followed by every high court, my lord, because I am coming from a high court where we are struggling still with digitization.
It's all in the mind, actually. Judges just have to look at my colleagues, such senior colleagues, you know, who are here in the
But I am
Supreme Court.
full of
Taken
admiration
so
for your
well.
lordships, my lord. It's amazing. It's amazing.
One of the selling point of the Chief Justice is that if you use a digital device, you will, as you use more and more, you will look younger and younger.
But it has taken effect, my lord, evidently. But my lord, not only that, my lord,
Incentive, my lord, that's the incentive.
but not only that, my lord, I as a my lord, infrequent visitor to the Supreme Court, my lord, the transcription is brilliant. My lord, the video conference system is absolutely
Yesterday
brilliant.
you argued for such a long time post lunch.
but it is absolutely brilliant.
There was not even a moment where we felt we had lost the voice or, you know, that we are not able to follow what you are saying.
My lord, it is absolutely brilliant. And because this is a national court and people have difficulty traveling to the court, the cost expense, my lord, it is a wonderful initiative. My lord, long may it continue.
That more and more lawyers from the High Court will have access to our digital courts, so that
It should be so, my lord. And I'm sure your lordships are aware, my lord, that in
remote areas also, people coming from remote districts.
internet is available now almost everywhere. my lord.
Not just, you know, the significant constitutional cases, but simple cases involving citizens.
My lord, it's a remarkable movement forward.
In fact, what we have now done, I can share with you, I mean, for those who are tech geeks, that we are now we are migrating all our services into what is called the Meghraj Cloud 2.0, which is the cloud infrastructure created by the National Informatics Center.
My lord.
So we've already migrated most of the applications of the Supreme Court and of the eCourts project also. Almost 200 VMs have been migrated. So with the cloud infrastructure now, all courts can really go online. Earlier we had some limitations because of the capacity, but which all of us have now moved into the cloud infrastructure. And these are managed services. You don't have to maintain a building. You don't have to maintain, you know, whole
Of course.
team of a cadre of technical personnel.
Of course, my lord.
It's all managed for you, and the data is all preserved on servers in India. So there's no problem of, you know, data going outside India or anything like that.
Not the only suggestion that I would make, because I know your lordship is at the forefront of this, not is uniformity. Your lordship system is so perfected. Lord, I wonder why other courts don't adopt the uniform system and the tribunals don't adopt it also.
In fact, I've got a matter where I've issued notice and
Well.
appointed, I think, 2 or 3 amicus. And that should come up probably once before we close for the vacation, just to monitor what the high courts have been doing. Some high courts, for instance, said, if you want to have video conferencing links, you must tell us 48 hours in advance. Some high court said, you can get a video conferencing link only if you are above the age of 60. So we had to pass a judicial order that what's this, why you, and the link should be in the cause list. Why should you apply 2 days in advance for a link? And why should we tell people that you will be only if you're a senior citizen, you will get a link? It's agnostic to age. Technology has nothing to do with age. So we're monitoring it and passing some.
But I feel a few words from your lordship will iron out a lot of creases at the high court level, because of course my experience is actually at the high court level.
Also, it was, Mr. Andarjan, it was a question of creating infrastructure. Now, what has happened, fortunately, was that government has sanctioned a budget of actually 7,000 crores for phase 3 of the eCourts project.
Madam.
And we've got the high courts also now on the eCourts project. And between November and now, 31st of March, we had to expend about 850 crores, which was the first tranche, which was meant that we're creating infrastructure for the high courts and the district judiciary. So high courts spent almost 94% of that amount. So hopefully with that now, the infrastructure in the high courts will really be upgraded so that these problems which they faced in sort of having a robust IT infrastructure will now disappear completely.
I hope it all works out. It's a
My
wonderful.
lord, I have also taken instructions from the government so far as, my lord, our role is concerned. And there is a direction from the Honorable Prime Minister give first priority to digitization, because access to justice to the common man is possible only when there is a digitization. He may not have to travel all the way to the High Court or to the tribunal, as my learned friend says, and he can access lawyers, local lawyers, those who are practicing in the district courts. Also, that's the priority of the government too.
Simple things like, for criminal trials. Trials don't have to be adjourned because the IO is now posted or transferred elsewhere. So we are ensuring that, we'll have video conference equipment in the, not only in the district courts, but in the jails, enhancement of that equipment, in the forensic science laboratories, in the hospitals. So where medical evidence is to be given, why does the doctor have to come to
The court.
the court to prove a dying declaration? The doctor is there. I mean, and imagine what a loss of productive time for medical personnel who have to travel in large states to the center of the.
I don't wish to go into that, but the new law also takes care of that. Electronic evidence would be electronic in the sense that a deposition given electronically would be treated as an evidence, valid evidence.
We're moving very rapidly by pushing the high courts to upgrade their infrastructure. And the financial backing is there. I mean, otherwise, what happens is there are state governments who are good with finances. Other state governments don't give even a farthing to the judiciary for IT and so it's now money goes straight from the government of India through the committee of the Supreme Court to the High Court. So there's no issue of of the money not being actually allocated by the state governments.
No, it has been a huge, huge improvement, my Lord, with regard to the access to justice also for many, many people.
Yes,
Lord, if your
Let's
lordships
see
all
what you have.
have the note now, my Lord. My Lord, I have just formulated the question, my Lord, if it pleases your lordship to look at this, my Lord. The issue in the, do all of your lordships have the note? Yes. My Lord, the issue in the present case specifically concerns the constituent power to vary a provision of the Constitution by substituting existing language by new language. The issue is the effect of the court declaring a substituted provision of the Constitution and or the Constitution Amendment Act, bringing about the substitution unconstitutional on the ground that it is beyond constituent power of Parliament to amend the Constitution. Lord, forgive me for using the technical language, but I thought to formulate before your lordships, Lord, we should use the correct technical language with regard to constituent power. Lord, briefly stated, Lord, what happens when the court declares a substituted provision to be unconstitutional? That is the question which presents itself before your lordships. Lord, I've just illustrated the 3 types of legislative constituent activity, Lord, by extracting 368 for your lordship's consideration. Lord, power of Parliament to amend the Constitution and procedure. Notwithstanding anything in this Constitution, Parliament may exercise its constituent power. How? Lord, in 3 ways. By way of addition, by way of variation, or repeal any provision of this Constitution in accordance